Imagine this. You're pulled over, handcuffed, and now the officer is digging through your glove box and your trunk with no warrant, no consent, just you and a sinking feeling. Hi, I'm Rick Fletcher, a criminal defense attorney in St. Petersburg, Florida. I filed and won motions to suppress when police illegally searched a client's car and tried to justify it with a sneaky tactic called an inventory search. Now, in the next few minutes, I'm going to explain when police can legally use this exception when it crosses the line and what you can do to challenge it. Now, let's get into it. There's a loophole in the Fourth Amendment called the inventory search. Florida officers love using it. And if you don't understand how it works, you might lose your rights without even knowing it. Now, this exception started with the United States Supreme Court case of South Dakota v. Opperman. In the Opperman case, police towed a car for illegal parking. During a routine inventory, they found marijuana in the glove box. The court said that's okay, not because they had probable cause, but because they followed a written policy to document the car's contents. They weren't looking for drugs, they were protecting the owner's property, avoiding theft claims, and securing officer safety. But here's the catch. That search was valid only because it was done under a standardized policy with no intent to gather evidence. So as the court put it, the inventory was conducted only in accordance with standard police procedures and not as a pretext for an investigatory search. And that brings us to Florida. So let's look at three real cases where Florida courts have decided when police have crossed the line. The first being Ross v. State. The case in Ross involved a person pulled over and arrested. Officers searched his car, claiming it was part of an inventory, but they couldn't produce any written inventory policy. In fact, the officer admitted he made the decision to tow and search based on his own judgment. So what made this case unique? There was no written inventory policy produced at the motion. The officer made the call independently. There was no evidence the department required inventory searches during these circumstances, and the second DCA held that the evidence should be suppressed, stating that without proof of the standardized criteria, the search was unconstitutional. Quote, the state presented no evidence of any policy or standardized procedure governing the impoundment or the inventory search. So why does this matter? If police can't prove that they followed a written procedure, it's not an inventory search, it's an illegal fishing expedition. Next, let's talk about Wall v. State. Wall was arrested on an out-of-state warrant. Her purse was left inside a vehicle which was legally parked in a private driveway. Officers later returned and searched the purse, claiming inevitable discovery or an inventory search. Now, what made this case unique? The car wasn't being towed, and there was no active impound procedure. The officer gave no clear explanation as to how or why the purse was searched. No checklist, no policy, no documentation. So the court held that the evidence should be suppressed, that there was no lawful basis to conduct the search, and the state failed to establish the requirements for an inventory or inevitable discovery. Quote, an inventory search conducted without standardized criteria or routine procedures amounts to an investigatory search. Why does this matter? Searches must happen at the time of the impoundment, not hours later, and only if backed by a written policy, not officer habit or preference. Now let's contrast this with the Holyfield case decided just this year. In the Holyfield case, Holyfield was arrested for driving a suspended license, his vehicle was lawfully towed, and the officer conducted a detailed inventory at the scene. What made this case unique was that the entire search was captured on body cam. The officer stated he was conducting an inventory and used a written checklist in accordance with department policy. Every step was documented. Now, the subjective motivation became an issue because the defense tried to argue that the officer was really looking for contraband based on some statements he made on the body cam. But the court used an objective reasonableness test, and it doesn't matter what the officer was thinking, it matters whether the procedure was followed according to the policy. Quote, the officer's subjective motivation is irrelevant if the inventory and the impoundment is done according to standardized procedures. Why does this case matter? Because Holyfield shows that even if the search turns up incriminating evidence, it can still be legal if the police follow the rules exactly to a T. But if they don't, like in Ross or Wall, the evidence can be thrown out. So here's the bottom line. If your car is impounded and searched, the only way the search is legal is if, number one, the impound was justified, number two, the department had a written inventory policy, and number three, the officer actually followed that policy. If any of those are missing, your attorney can file a motion to suppress, and any evidence they find could be excluded. So how do you protect yourself? If you're ever in this situation, don't give consent to a vehicle search. Ask the officer if the car is being impounded and request a copy of the inventory form. If you have valuable private items in your vehicle, consider locking them in a separate container. Why? because courts are more likely to view a warrantless opening of a closed or locked container as an investigatory search rather than an inventory, especially if the officer had to go out of his way to pry it open. The bottom line is a locked container helps you draw a line between what's routine and what's unreasonable. It signals privacy, and it may be the difference between admissible and inadmissible evidence. So if you found this video helpful, make sure to like and subscribe to our YouTube channel. We have all sorts of legal breakdowns. Call Fletcher and Fletcher if your rights have been violated during a traffic stop. We fight back against illegal searches and seizures, and we know how to win. Thanks for watching, and stay tuned for the next video.